Ladies and gentlemen, I'm sure there's a few fellow surveyors in there, although I don't know if there's any quantity surveyors, of which I am one. My name is John Curtin. I'm the President of the Society of Chartered Surveyors Ireland, and you're all very, very welcome to our seminar this evening entitled, as behind me, Apartment Ownership under the Multi-Unit Development Act. So if I could just flag a few points of order before we just get going. Just to point out to you the emergency exits. There's an emergency exit to your rear and right, and an emergency exit to your front and right, just over here. If I could also ask you to turn off your mobile phones. Now our main presentation will be about between a half an hour and 40 minutes, and we're going to do a question and answer after the main presentation. If you could keep your questions till the very end, maybe make a note of them, and we'll answer them as best we can. Just a couple of things on that. It's not intended to give specific legal advice on anything here this evening, so please don't take anything we say as legal advice. And indeed, if there are questions, we'd be happy to answer them if they're of a general nature, and we obviously can't get into questions and answers on specific developments or specific issues or problems with developments if they exist. Okay, so just moving on. Firstly, who are the Society of Chartered Surveyors? You thought this was free, but you're going to have to listen to me for a couple of minutes, so my apologies for that. That's the buy-in. The Society of Chartered Surveyors was formed after the merger of the the Society of Chartered Surveyors Ireland was formed after the merger of the Society of Chartered Surveyors and the Irish Auctioneers and Valuers Institute, which happened earlier on this year, in April of this year. But the various bodies have been around for a long time before that. Indeed, they go back to 1895 and 1922, respectively. So, whilst we are a new organisation, we have very, very deep roots. We're a charity, and we rely on the support of our members. We've about 4,800 members, 800 of which are students. Our mission statement is up on the board behind you, and the most important part of it, as far as I'm concerned, is for the public advantage, the last four words. In other words, we're not a lobby group, we're not here to sell you anything, we're here to inform you, and really to inform the public. We are a very broad church, and sometimes because we're a broad church, we tend to suffer from a lack of identity. Quite simply, our members might be involved in doing things as far removed from one another as valuing a Jack B. Yeats painting, to building roads, or indeed selling houses, or valuing leases, or valuing commercial property. Indeed, the reason we're here this evening, of course, is because a number of our members involve themselves in property and facilities management, and indeed taking over of properties, snag lists, building defects and the like. You can see the various groups up there on the board behind me. On the property side of the house, we've agents who operate in two markets, residential, commercial. We've valuation surveyors, property and facility management surveyors, art and antiquities surveyors, and then construction and land, quantity surveyors, building surveyors, planning and development surveyors, etc. So we're a very, very broad church. I think when somebody says surveyor, it's not quite easy just to pigeonhole surveyor. Kind of, I suppose, if you were to think about doctors, you'd have a general practice and then you'd have specialists. And so the purpose of this evening's talk, I beg your pardon. So why use a chartered surveyor? Well, everybody who is a chartered surveyor is professionally qualified, and that essentially means that the qualification is the equivalent of a level 8 qualification, which is an honours degree level with experience on top of that. We have what we call an assessment of professional competence after a level 8 qualification. Everybody's trained, experienced. We set ourselves and align ourselves with the Royal Institution of Chartered Surveyors. You'll see the emblem there in the bottom right hand corner, and they are the international body with about 150,000 members around the world who give us guidance and assist us with governance and the like. We have a regulation department, and indeed we get assistance from the RICS, who have about 100 regulators who regulate, and all of our members carry professional indemnity insurances. And so, to the Multi-Unit Development Act, I suppose, sorry, that's the sales bit over, you can relax now. I suppose it could be said that this is probably the most important act to affect apartment owners since the foundation of the state. I believe it empowers apartment owners, but of course is not without its responsibilities for those owners. You know, I think ultimately it's going to lead to better apartment living, and incidentally, you'll note the Property Services Regulation Bill is making its way through the Oireachtas at the moment, and it incidentally also provides for the regulation of property management agents. So here to speak about the Act is Siobhan O'Dwyer. Siobhan is a chartered surveyor and she's the chairperson of our Property and Facilities Practice Group. Siobhan was heavily involved with the Law Reform Commission forum that fed into the development of the legislation, and is the chair of O'Dwyer Property Management. Joining us for the questions and answers is Mr. Pat McGovern. Pat is the chair of our Building Surveying Practice Group. The building surveyors obviously involve themselves in such matters as preparing snag lists, identifying what needs to be done prior to handover from builders, and involve themselves in building defects. Pat is also the Managing Director of McGovern Surveyors. So again, I thank you very much for your attention. It's great to see such a good turnout here this evening. And with that, I'll hand you over to Siobhan. Siobhan.
I'm going to be talking about the Multi-Unit Act, and as John said, it's an overview of the Act, and it's a very practical perspective of what the Act provides for. It's not a legal interpretation, and I think there will be, because it's a very complex piece of legislation, there will be many interpretations of it. So it's not for me at all to put my own views on that, but I will try and concentrate on what I believe are the implications for apartment owners today and in the future. In my introduction, I'll talk about what it is and what it seeks to address. Under the background, I'll talk about why it came into being, what the conditions were in apartment living, what the problems were that brought about the drafting of the legislation and the need for reform. In terms of the application of the Act, what buildings it affects. And under the general scope, I, for my own simplistic terms, break it down into 4 different areas. And that might help you also understand it. It certainly helps me. I'll then talk about what it generally means to consumers and to apartment owners. And after that, I think we'll have a Q&A that might address anything I leave out, which probably will be plenty. So in terms of my introduction, the Act, the Multi-Unit Development Act, is a new legal framework which was enacted on the 1st of April 2011. It seeks to address problems, 3 items, and this is from the statute. Problems relating to the ownership and management of the common areas of both existing and new multi-unit developments, and to facilitate the fair and effective management of bodies responsible for the management of common areas, and thirdly, to provide for related matters. And whilst 1 and 2 of those problems in the ownership and management and problems with the facilitating of fair and effective management, whilst the Act started out really to look after those 2 headings primarily, the third area, related matters, became much more developed. There are a lot of the amendments that were provided into the Act came under that heading, and really a lot of people would now say the Act is actually regulation of developers by the back door, because under related matters there's an awful lot of stuff about completing the development, the certification and compliance of development, and documentation relating to the quality of building regulation or compliance with building regulations and building control. There are, as I said, many issues of interpretation, and I think it is expected and commonly believed that there will be lots of challenges to the interpretations of the important pieces of the Act. So until those challenges occur, we may not really get clarification on what the outcome will be. Finally, I'd just say in my introduction on the Act is that it was designed during better times. So unfortunately, the Act doesn't provide solutions for some of the problems that have occurred in recent times with developers going into receivership. So unfortunately, it doesn't accommodate those. So to just go into the Sorry, I'm going backwards now. Oops. So on the background, why the Act was necessary. Anne Fitzgerald, the chairman of the Consumer Association, made a statement that has always stuck in my mind, that she said that there was more consumer protection in the purchase of a kettle in Ireland than the purchase of an apartment, and that was after she had done quite an extensive amount of study with a group on what were the real problems. And just really to explain why she came to that view, what was unearthed during those investigations, it was identified that obviously apartment living was a new form of housing. I think we had our first apartment development in 1974. And there wasn't, we built the developments without really providing for a legislative framework for them. And I think the conveyancing documentation and the state documentation that was developed, I think the very first solicitor was asked to put together a suite of documentation for the sale of the apartments in this new development, said, well, I haven't anything on my, a precedent document. So what I'll do is I have an office building here, and I'll strike out the word office and I'll put in apartment, and we'll work through it. We'll sell these, we'll develop a suite of documentation on that basis. So you can imagine that office documentation would not have accommodated all the needs for apartments. But the documentation grew from that point, and not a good starting point, obviously. The documentation was extremely absent, in particular in relation to completion and handover. And in multi-unit development, we often have the sale of apartments going ahead, off plans, or whilst the rest of the development was being constructed in phases. So the buyer would have already passed over 100% of their money and moved in, and maybe be then at the subject to the goodwill of the developer for the completion and for the handover of the common areas. This obviously wasn't an appropriate process. It shouldn't be down to the goodwill of anybody. It should be contractually arranged and processes in place that everybody understood how these things would happen. There were limited regulations for the owner's management company, the OMC. The OMC had a very limited list of responsibilities, but it didn't really address many of the extra complex matters that arise in multi-unit living. It also was an entity without any real legal capacity to have any power or control whilst the developer was still on site. And often the owners would turn to the OMC or the management company expecting it to have some sort of means to address issues. And of course they would be very disappointed to learn that it didn't have any more power than they individually as a purchaser had. Then generally there were compliance problems with building regulations in Ireland generally, and building control, which I think Priory Hall has somewhat highlighted. When problems were identified, then the enforcement measures were often difficult. Sometimes they were just issues to do with the common areas that might not be sufficiently big enough for the planning office to consider matters that they would enter into and become involved in through their enforcement procedures. So there was a big gap there in what owners could do. But this might mean the absence of a bin store, or the absence of vehicular gates, or additional apartments built on the green areas. So it was quite considerable, some of the problems that arose, that there was no recourse to resolve these under the arrangements that existed. The booming economy also contributed to the problems, because we sort of were relatively complacent about small problems if our values were considerably growing. So I think that really obscured the fact that these problems existed. Oh well, if my common areas haven't been finished as well as I thought they might have been, but at least my development or my apartment has gone up by 20% since I bought it, or whatever. So that kind of obscured the issues. The fact that there was limited public comprehension as well. Our parents didn't live in apartments. We hadn't learned from them about what we should look out for. When we bought apartments, we didn't really know much about what the service charge included and the requirements for it and how it would all operate, and how multi-unit development wasn't really just moving into an apartment and letting somebody else do it all for us, that there was a role to play. And certainly if our parents had lived in them, I'm sure they would have passed down that guidance. the adverse media concentrated on the service charges and how this was a burden and an imposition on apartment owners, and really the media didn't go any deeper than that issue itself. And while there was problems with service charges, the issues were far greater than that, because if you scratched the surface at all, you found that people were aggrieved paying their service charges, not because they didn't feel the service charge was validly due, but maybe because the development wasn't finished properly. So that was disappointing that they didn't go any deeper to really highlight where the real issues were. Anyway, public complaint nonetheless stimulated the reform, and the Law Reform Commission undertook their study. The Director of Corporate Enforcement, the ODCE, did a huge document on guidance for management companies. The National Consumer Agency got involved, and we ended up eventually with the the draft of the multi-unit bill in 2009. It then took a few years and was only enacted in 2011. And during its course through the houses of the Oireachtas, it went from, I think, a 9-page document to a 20-something page document. So it was amended extensively from lobby groups from all over the country, from different areas, including the SCSI and the IAVI and other professional bodies, and that were keen to ensure that the Act was sufficiently adequate to provide for better consumer protections and more consumer confidence in the purchase of apartments. So that's the background. So I hope I haven't painted too negative a picture there. Moving on then to the Act itself and who it's applicable to. It affects existing and future multi-unit developments. The legislation is obviously not retrospective or can't be made retrospective. So the legislators acknowledged that existing multi-units developments had problems, and in the Act they have provided remedial measures for them to address those problems, and they've then provided a better regime for future multi-unit developments. So there's some parts of the Act that affect existing and future, and some that only affect future. A MUD is a multi-unit development, or any unit within a development where there is not less than 5 units and where amenities are shared. It also affects mixed-use developments, and a mixed-use development is a multi-unit development with a commercial area, like a shopping centre maybe on the ground floor, or some offices or retail areas. Not a creche. A creche actually is not considered a commercial property in terms of the MUD Act. And it also affects private housing estates where there is an OMC, where there's an owner's management company which is entrusted to manage the common areas for it. So it also affects that. And it affects all of those in slightly different ways. As I said, I've broken down the general scope of the Act into 4 key areas. I've done this. The legislation isn't broken down like this. In fact, the legislation is the Act is quite complicated to read, because all the amendments came in from 2009 the whole way through to 2011. And often when I was reading it, I thought, why didn't they just take it back in and rewrite it all again in an orderly fashion? It would make it so much easier for us all to understand its intentions. So I've broken it down that it mainly is to do with obligations in relation to the compulsory vesting, or what we know as the transfer of the common areas by the developer to the OMC. And I'll talk individually about each of them separately. Obligations of the developer upon completion, and this is to do with all of the whole area of assuring completion and the verification of compliance and so forth. 3 is the remedial. It provides remedial mechanisms for dealing with disputes and gives quite an extensive arrangements for different types of situations that it can now, those remedial measures can be used or availed of. And then it sets up very strong new regulations, rights and obligations of the OMC. It makes the OMC, the management company, a far more powerful and strong company to operate in its role as in managing the developer, and removes really a lot of the control and power from the developer, which heretofore at the early stages might not have been a bad thing, but down the road it was probably inappropriate in many cases. So to just go into each of those then individually. Number one is probably the very complex part. I'm not going to delve too much into this one about the transfer and the ownership of the common areas, but the Act sets down that in future multi-unit developments, that the common areas must be transferred to the owner's management company before any sale can occur. So when you move into you purchase your apartment and move into your development, the common areas will already be owned by your management company. The developer will retain a beneficial interest in them in order to complete the estate and to move past and work on the development. But in effect, the legal ownership will be vested in the OMC from the start, and that means people will be able to have a say immediately in their OMC. But in existing multi-unit developments, the legislators were very aware of the number of developments that had not yet been transferred over to their OMCs, and owners wanting to control and wanting to effect good arrangements in the management of their developments or sort out problems couldn't do so because they didn't have legal control of them. So the legislators, the Act requires that in existing MUDs, all common areas must be transferred within 6 months of enactment, which would have been the 30th of September 2011. We know that not all multi-unit developments have not been passed over or transferred. And the big question people are always asking is, what are the consequences of that failure not to transfer by the 30th? Well, it isn't a criminal offence, but there are means to petition a court, and if a court order was made, then of course it is a criminal offence if the transfer hasn't been made. I could talk for the next hour on these two headings, and it's a very legal element, part of the Act, so I'm going to move swiftly on from it and get into the more practical ends of the things that I'm more familiar with. The next sort of section of the Act is all about the obligations of the developer upon completion, and this is all about how I suppose the problems in the past where somebody bought their apartment, they were always would have believed that if their certificate of compliance was there, that they would have some assurance that the development would be completed. But in fact, in Ireland, under the old regime, the certificate of compliance that you bought your apartment with actually confirmed compliance for your 4 walls in simple terms, but outside of your apartment it had qualifications, and those qualifications, many people didn't really understand that the qualifications actually mean exclusions. So in effect you had a certificate that warranted you about the well-being of your own apartment, but didn't really give you any assurance about the rest of the common areas or anything outside of your 4 walls. The Act now requires that the developer must provide, and in fact, sorry, I'll just bring in Pat McGovern's role, and often in developments, there would be, at the stage of the completion of the development, Pat McGovern and building surveyors of his like would be brought in by the owners to do a snag report, and then it would be down to negotiating with the developers for the completion of that snag report. And it really would be, as Pat will tell you, up to the goodwill of the developer to complete the snag list, because it was very difficult to force that list of works to be done. So the Act really acknowledges the absences in this area, and it requires now that there's a certificate of compliance for the entire estate, for the completion of the entire estate, before the developer's beneficial interest extinguishes or before handover. It also mandates over a whole load of documentation that in practical terms in other countries would be absolutely standard practice, would be handed over to the management body or the OMC for ongoing arrangements for the management of the development. And that would include, items such as the safety file, as-built drawings or service and as-built service drawings and as-built structural drawings. So if you, for example, you had a burst pipe, you could look at the drawings, know where the pipework went or the basic design. It would not take you a whole load of opening up before you could find out where the source of the leak was, or various other different problems that you might come across a few years later. Those drawings can be invaluable. O&M manuals for plant and equipment. Often management companies don't know what they have to manage, don't know the plant and equipment in the development that needs to be maintained. And obviously, like for example, lifts can have a 30-year lifespan, but they might only have a 30-year lifespan if they're maintained properly. And in fact, not actually looking after them properly is probably in the long term going to cost you a lot more money than looking after them up front. Well, to start with some knowledge and information on what's in the development, that sort of information is essential. The Act also mandates that the warranties and guarantees provided by subcontractors to developers are the benefits of those warranties and guarantees are passed over and transferred to the management company. So the management company, irrespective of where the developer is, could also but could just get in contact with the roofing contractor or everything to say if there was some problem with it, and could call in on a warranty and guarantee. That would be very practical and very helpful. The Act goes into, the list is quite extensive, and there is some duplication in it, but it also requires for even things like test records for drainage, water pipe and heating pipe work. And I think it is an acknowledgement of the number of consumer complaints that there was no testing of the water systems, and so people would move in, turn on all their you start to use their kitchens and their bathrooms, and then you'd have a number of leaks before they can be all patched and fixed up. So not a good way to start a management programme at all. Also, the Act requires that all title documentation for the estate and the OMC statutory books are handed over at completion as well. And obviously they're very essential for the ongoing arrangements for the development. And the stamped and registered counterpart leases for each and every individual purchase are absolutely essential. If an OMC wants to go into court to collect service charges that are owing by one or two owners that haven't been paid, unless you have that documentation in court, no judge will give you an order for payment. So they are vitally important to the proper operations of your management company. The third provisions that the Act provides, the third element or scope of the Act is that it provides, as I said, in existing developments, new remedial dispute mechanisms for owners to help them resolve their problems. It provides, it designates the Circuit Court with exclusive jurisdiction, so it's a cheaper court than the High Court, no matter what the cost of the issue is. It designates the Circuit Court. It also stipulates in the Act that any cases are to be directed to mediation. And in the Multi-Unit Act, it says under mediation in itself would be a speedier process and a less costly process for anybody having to undertake this. But also the mediation process stipulated in the Act, it requires broader rules than the standard rules for mediation, in that if mediation fails, a report must go into the judge explaining why it has failed. So it also will encourage people to cooperate with mediation, because nobody will want the judge to hear that they weren't cooperating. So it will probably be a much more effective process. The Circuit Court can be used to enforce any obligation under the Act, and it could be anything from enforcing any right to altering voting that's been demonstrated to be unfair or inequitable, to direct a rearrangement or apportionment of funds which was inappropriate or irregular, say to determine issues over boundaries or alterations that are needed or changes to the development, to amend covenants which are considered to be unfair, or to enable an OMC with a debt which is unrecoverable, or say if there was a decision made by the majority of owners. Currently in an OMC, if you want to make a big decision, you need the majority, like 100% of the ownership, to agree to it. So if you have one person who doesn't agree, all the other owners have to accept that they can't go ahead with their decision. So the court would be able to review, the basis of the majority's decision to make a change and to make an order in favour of the best interest of the development and the majority of the ownership's wishes. So there's many other situations as well that the Act provides the Circuit Court for those sort of remedial measures. And finally, there's a lot of struck off OMCs, unfortunately, around the country where they haven't been operated by the developer initially and then not taken up by the owners, and they end up being struck off. But the problem is that effectively you can't sell your dwelling if they're struck off, and the period for reinstatement that you could apply for reinstatement to the company registration office was 1 year. That's now been extended to 6 years to acknowledge that there are a lot of OMCs that need to resolve that problem to ensure they've got good title to their property. So the fourth area then is new regulations on the OMC for governance and reporting. I think that the Act very definitely gives much greater rights for all the owners in terms of equal voting rights. It provides for one vote per unit. And any existing greater voting arrangements are absolutely not permitted. If anybody wants to exercise, if somebody has an inappropriate level of voting rights other than one unit, one vote, then if they want to exercise them, they actually have to make an application to the court to exercise them. So it actually mandates the continuance of any unfair voting rights. Whilst it gives greater rights to the owners and the members of the management company, it also puts a lot more responsibility on the OMC directors, which are actually coming from the body of ownership. The directors must ensure adequate funding and the maintenance of the development. So there is a real responsibility on anybody acting as a director to ensure that they are adequately funding, providing for the adequate funding, and that they're ensuring that the maintenance of the development is looked after. There's an onus on them to ensure value, and value doesn't mean the cheapest. It means, the appropriate criteria is used for the selection and delivery of services. Contracts cannot be any longer than 3 years, and that's to ensure there's a good rotation and a good appropriate selection process for landscape gardeners or for cleaners or for management agents or whatever. There's a big requirement for reporting and consultation with the owners, and the directors can only serve a maximum term of 3 years in the role of directors. Now, after 3 years, they can go for re-election and be re-elected immediately for another term of 3 years. But it's to make sure that there is a good recycling. And obviously, I think it's aimed at ensuring developers, when they've done the transfer of the common areas, they don't hold on to the control of the management company inappropriately for any longer during the future without being elected by the owners or the members. In terms of, my order is a little bit skew-ways here, but in terms of reporting and consultation with the owners, the annual report now, we would be already relatively familiar with the audited accounts that you might get once a year and an invitation to the AGM. Well, this process now, the annual report is far more onerous on the OMC and the directors. It needs to be a statement of the assets and liabilities, but also a statement of the sinking funds, including details of the basis and calculation of the annual contribution, the annual service charge and the details and the basis of its calculation, details of any planned expenditure and refurbishment improvements or maintenance intended to be carried out, the insurance and the insured value, details of the premium, the insurance company, and a summary of the principal risks covered. And this is probably highlighting the fact that we actually have a number of apartment developments where there is no insurance, and I think the owners living there are not aware of it. So this will put a greater onus on whoever is operating the management company to disclose that information and confirm that there is adequate insurance. And then finally, a statement setting the annual report is also to include a statement setting out the fire safety equipment installed and the arrangements in place for its maintenance. So even before Priory Hall, there was an acknowledgement in the Act that there was a weakness in the fire safety arrangements in multi-unit developments, and the Act acknowledges it by at least putting a requirement on the management company to disclose the arrangements, and also maybe to help the consumer be aware of the need for fire safety in the development. under those new regulations, one of the biggest areas is regulations for the service charges. From now on, a developer must establish a scheme for the annual service charges from day one. We have had situations where no scheme was set up, sometimes even no OMC was set up, and the developer is required to set the initial charge, but he must disclose the details to the purchasers. So in the past, one of the biggest impediments was where at the initial stages of the sale of a development, an inappropriate or understated amount of money was told, the service charge would be disclosed as an understated amount would be suggested as adequate, so it would be maybe told that the service charge is going to be €1,000 a year, but in fact really the requirement was €1,500 a year. There was no doubt in most people's minds that that was to encourage purchasers and maybe to mislead somewhat. It was an unfortunate situation. But that now, the Act goes a long way to trying to ensure that that doesn't happen by at least disclosing the details to the purchasers. And interestingly, in Ireland, we have in terms of apartment ownership, we've had a big concern about the cost of the service charge, whereas abroad the first question isn't what is the cost of the service charge. The first question is what are the services that will be provided in this development, who will be providing them, and what are the arrangements for them. So we have been very upset and hurt by the fact that service charges have been imposed on us without the information and the proper arrangements behind them. But maybe this will go some way to correcting it. The Act requires that service charges must be transparent and fair, that the details and categories of the breakdown of the expenditure must be outlined in a budget. So no more should you be getting an envelope with a bill in it saying, 2,000 please, without a full breakdown of exactly the services that are to be provided for that £2,000 or whatever the amount might be. Thereafter, after the first year, the board of directors will agree what the adequate service charge will be, and then those figures will be circulated to the owners, and at a general members meeting they must be approved by the owners, or they can be disapproved by 65% of those present, and if they disapprove them, then the previous year's figure stays or remains until a new figure is agreed. So it gives a lot more control. I think it adds a lot more a burden on the directors to go to all the trouble of deciding what they feel is the appropriate level, and then maybe to be challenged by their own neighbours. It's going to be very, I think, a little bit difficult, but nonetheless that's the way the Act has gone, and its intentions are to provide for a lot more say on the owner's part. All owners are legally obliged to pay, including the developer, for unsold units, and this would be very welcomed in new developments or phased developments where developers retained units or had unsold units, and the contributions owing from those units were burdened on the first purchasers into the development. It was an unfair arrangement. It's now outlawed and it's not happening anymore, and it's a welcome thing that it's not happening. I'm not saying all developers did it. Some developers, there were many developers who paid in their contributions and they were voluntarily paid in, and that arrangement shouldn't have been the case. It should have been, contractually arranged in a proper process. The Act also acknowledges the difficulty in collecting unpaid service charges, and it has altered the arrangements to now regard it as a simple contract debt, which will make at least the process in court somewhat easier. There would be a lot of people who would be disappointed that the Act didn't go a bit further in helping collect unpaid service charges, particularly from investors who might live abroad, who own multi-unit developments where the lack of their contribution really does hurt the existing owners that are at home trying to manage the place without it. Funds must not be used to defray developers' expenses, and I think it's an acknowledgement that bad practices were happening in the past. And then it requires that proper records of expenditure for auditing purposes are maintained at all times. I think whilst the regulations for service charges are onerous and probably all of the Act will increase the cost of service charges, the real benefit will be that our buildings will be well maintained and not suffering from dilapidations in future if we embrace and take on property management in the regime that the Act proposes. There's also new regulations for sinking funds. The Act stipulates the requirement for a sinking fund. It's clear that long-term provisions were not being made in all developments, and then when refurbishment work was coming up, for the example, small, obvious things like the painting and decoration of the common areas or recarpeting, or more serious things such as new parts for the lifts or health and safety matters, or more the things that Pat would tell you about. That when it came to needing money for those jobs, there might have been 4 or 5 changes of ownership, no funds there, and nobody disposed to come up with a levy to pay for them. And of course, the development then sinks into dilapidations. And of course, now with other problems that we have with affordability, this will only make the problem harder for everybody. The Act, anyway, stipulates the requirement for a sinking fund, and it highlights that the OMC should and is entitled to retain professional advice from building surveyors to determine the requirements of the sinking fund, to plan for the future, to identify what the needs of the building will be in the future, and to provide adequately for them. The Act says that every owner must pay the sinking fund. Developers must pay on behalf of unsold units. And the Act stipulated that the sum paid should be €200 or such other agreed sum. And it was interesting watching the Act go through the Houses of the Act as the cost of the contribution went up and down depending on the lobby groups on the time, and it was €200 for a long time, and then just about 2 or 3 days before the Act went through, it was changed to or such other agreed sum by the owners. So whether that was pressure from one particular group or whether it was to allow for issues of affordability or what it was, but that's it gave a bit more flexibility. I'd like to think that the flexibility was there to allow for owners to determine, with the advice of building surveyors, depending on the scale and the design of their own development, what was the real requirement, and that it would be more up to their own decision. In existing developments where there is no sinking fund, one must be established by September 2012, if it's not already in place. And in future developments, the sinking fund must be established within 3 years of the sale of the first unit, which is a bit unusual because best practice abroad is immediately from a small amount from day one rather than after 3 years. Again, it's kind of a bit like the old-fashioned way of avoiding things and then increasing the cost in 3 years' time is not going to be well received. It would have been better to have a smaller amount from the start. Sinking funds are to be held in a separate bank account. And it is an effort to ensure that they are not used to defray expenses on a day-to-day basis, and that they are kept for bigger works down the road. And then on fire safety, whilst I said Priory Hall opened everybody's eyes to the concerns in multi-unit developments, the Act already did provide somewhat in future developments. It says that the developer must provide a certificate of compliance with the fire safety certificate, and that is before anybody moves into the development. And so that would give a huge level of assurance that might not be there at the moment. It also requires that certificate be provided by a suitably qualified person, and the description or prescription for that suitably qualified person has been now done under statutory instrument. And then so effectively there is no doubt that in future new developments there would be a lot more assurance. In existing developments, the OMC is mandated very definitely to have responsibility for the management of fire safety systems. Now, just to make sure that everybody realises, typical fire safety installations in a development include from fire detection, fire alarm systems, emergency lighting, exit signage, fire extinguishers, fire hose reels, dry and wet risers, smoke ventilation, fire doors, fire stopping, and a multitude of other small things. And some of them visible and some of them not visible, i.e. they're in the integrity of the construction. The Act requires that existing OMCs have to have a fire safety register and ensure that a maintenance programme is maintained. And they also then have to, in turn, for the owner's management company's report at the AGM, that they must confirm in that report that the fire safety arrangements have been attended to. So there's a big acknowledgement there for the need for fire safety and for OMCs to regularise things now if they aren't up till now. Finally, from consumer lobbying, people wanted a lot of changes to the house rule arrangements. They wanted more sanctions when people were making noise. I think what they were looking for was more municipal support, maybe from the police, that they could phone them and say, look, there's a party next door, would you knock on the door and tell them to be quiet or whatever. But in fact what we got was the right to make more house rules. And the Act says the OMC can create more house rules other than those that exist in the estate documentation at day one. They must be consistent, fair and reasonable, and they must be circulated to the owners and approved by the members at a general members meeting before they can be enforced. Landlords, as was before, must oblige their tenants to observe the house rules. And one thing they did put in was that the OMC can recover the costs of remedying a breach. So if somebody broke a window at a party one night, you can at least go down to them and say, here's the bill, and recoup the OMC for their costs in fixing the window. But I think people are disappointed that the real problem with noise didn't get, that the more serious concerns with house rules didn't get addressed in the Act. Just then finally I should mention that in sort of simultaneous to the Act, we're about to have the Property Services Regulation Act. I think it might have been in the Seanad today. And that is, as John said in his introduction, it will bring in the licensing and regulation of a lot of different property services providers, including managing agents. The regulatory authority, which is already in operation down in County Navan, they will set down minimum standards as to who can be licensed and who can operate as a managing agent. And I think that OMCs will then find appointing a new agent a lot more simpler process, because they'll be able to go to the register and select somebody and be assured that they have the minimum of qualifications to know what a fire safety system is, to know how to consider sinking funds, to know how to put together a budget, and all the different legal and corporate responsibilities that the OMC has to ensure that the directors and the owners of the management company are properly protected, and that the development is managed for the long term and not for the short term. Obviously anybody in the Society of Chartered Surveyors who is in the managing agent business is already on this register and licensed, so they would be very welcoming of this arrangement, which will clearly identify that we have had a very loose arrangement as to who can operate as a managing agent, which also contributed to the difficulties. I think that's it. Oh, what it means to the consumers in general, I think, to close off. Well, I think there are many pluses. The apartment owner now is assured of the transfer of the common areas, which hasn't been in the past. There are now more fair and equal voting rights. There is now new legal recourse to remedy problems that are out there. The OMC, the management company itself, is a far stronger entity and legal entity, and able to do a lot more and operate in a more powerful manner in the arrangements of the management of the development. particularly in terms of reporting to the owners and keeping them aware of what's going on, which will also encourage people to understand the benefits of management and why it's essential that their service charges are effectively an investment in their own property to ensure the ongoing value of that property. We don't have to go too far down the road to see an apartment that has been an apartment building that is well managed and the value it will get versus one that is badly managed, although I know in today's terms it's hard to discern anything like that. Sinking funds it's a huge acknowledgement that that the Act sees the importance of them, that we can't be having situations in year 10 where people are told to come up with €1,000 a head for the roof repair, or worse, 5,000 a head for the roof repair, that it needs to be a smaller sum every year for whatever requirements the building is going to have, and that's more acceptable and stomachable and workable in the interest of the development. That service charges are not a bill, just a sum of money, that they're fully explained and that we know what we're getting for our money. And that house rules, that there's modest new arrangements in that. I think generally it provides for enhanced consumer protection. We would hope that it would encourage consumer confidence more in apartment living down the road, and maybe we've a little bit more to go in that regard. But that's my interpretation, practical interpretation of the Act. I hope it's been helpful. Thank you.